the Act tell you? Why will the Act tell you? Will not guide you, hold your hand and tell you. It's so that that's why we have lawyers.
I can suggest a better answer with respect, my lord.
Yes, please do.
Now take for example 32. The arbitration comes to an end once final award is passed. Unless for other reasons that time is over, etc. Now once the award is set aside, there is no award in operation. Therefore, one can possibly take a view that the arbitration automatically revives.
That's not provided in the Act.
That's what I'm saying.
No, it is not provided. Automatic revival is not provided.
Their Act does not say so. Act does not say so. The point is, now take for example.
In one of the cases, with Sanjay Kumar, it was a case in which there was a claim made against the insurance company. Insurance companies, the arbitration clause does not permit you to arbitrate on the question whether the claim is payable. Only on the question of quantum of claim, arbitration is possible, as per the decisions of this court.
Sir, take a case.
So there, the third bank came in and moved an application to Section 8, which was allowed. And the matter was referred to arbitration. Award was pronounced, it was struck down that the arbitration clause is limited. We passed an order reviving of the suit because there it could have been possible because the suit was already pending.
Suppose the arbitration revives, it will be again the same round, challenge under 34, and this can continue ad infinitum. Then the cost involved in arbitration.
That is always so in remand.
Therefore, now 34 does not even contemplate even remotely of remand. Now one example I'll give you. Section 37 did not prescribe limitation. Your Lordship read into it. Your Lordships read into it because of.
Now we've removed it, we've made it applicable as per application.
Question is therefore, your Lordships are reading, not take for example, an arbitrator being appointed only by one party.
After we have understood this argument, anything else now on this?
So therefore, there is a void. Now, Mr. Datar argued that then supply some words. I am dealing on that part of the. I perhaps do not agree with him on that part of the matter. Your Lordships have consistently taken a view that a case of casus omissus is to be rarely and rarely invented. And in the absence of a clear-cut measure, your Lordship have to see the scheme of the Act, the object to be achieved, what remedies, judicial remedies are provided for. Now, in my respectful submission, in this case, we don't have to go in search of casus omissus. We don't have to supply words. The answer is to be found in Section 34 itself. And that answer is this. Take a case, for example, where there is enough evidence on the record of the arbitrator, but he does not follow. I am not saying wrong application, because now wrong application also door is sought to be closed by the proviso to 34(2)(a). I am conscious of that.
So you are in favor of court taking.
But suppose it does not follow. Now take a case of solatium. Take a case of solatium. The arbitrator does not grant solatium. What is to be done? The court is powerless. Now that would render that remedy under 34 an illusion. An illusion. The remedy has to be effective. And that has to be effective within certain definite time span. Least expensive. If these are the twin objectives of the arbitration law, then asking him to go back and then take it years, and by that time the real value of the money, what I get today, 100 rupees, after 20 years, it will not be even worth 1 rupee. This is the situation. Therefore, in my respectful submission, two propositions. One, that we are dealing with dissimilar situations, public law element in statutory arbitration, involuntary arbitration, as against that commercial arbitration based on contractual obligation. Therefore, we cannot have a same standard to measure the width and the amplitude of the court's power under 34. Otherwise, it will lead to infraction of Article 14.
Okay, thank you. Yes, please.
One minute. Sir, before I close, I don't want to show to your lordship, but there are several statutes which deal with statutory arbitration.
Correct.
Atomic Energy Act, Chit Funds Act, and all wherever this statutory arbitration is provided for, there are different parameters. In some cases, appeals are provided for.
Correct.
In some cases, a different kind of procedure is prescribed. Now, therefore, we cannot have one standard measure to assess the width and the amplitude of court's power under 34. It will be in my respectful submission.
Nowadays, you may be better off. Since power is not traceable, you may file a writ petition and show discrimination and get relief.
No, but
Whereas
then
the private party
then all principles of administrative law must apply. And
No.
then who can apply?
So if power is not located in the act, then it's not barred. You may file a writ.
No, but then if moment I come under 2 to 6, the first thing High Court tells me there is a remedy under 34.
No, but 34 doesn't provide
then-
for what I'm asking.
Then your lordship will have to hold that this is an illusory remedy, not effective.
According to what they say, and if we accept 34 doesn't provide for it,
No,
then
therefore,
it's a remedy only to be ventilated before the writ court.
therefore I am trying to avoid a situation that remedy becomes an illusion. So may I hand over the list of only those statutes?
That's fine.
List of
Yes,
those
please.
statutes. Because
One
your
by one
lordship
now.
have to consider this.
5 minutes now. 5 minutes and we will.
Will not apply of the act.
Yeah. And sir, one more.
One by one, if you give it your slips, they call you by name.
And second is the list of provisions of the Arbitration Act which can never apply to involuntary arbitration. Take.
Okay. All the names.
I am grateful. It is lot.
Compilation we are handing over, not appearing for a PSU, TCIL, and not the primary line of argument that we are having is for modification. If Lordship will just have the compilation, but we also have a ready compilation of chart. What we have done is, Lord, we have put a comparative of all sections, but I'll first, Lord, begin with the, what is the theme of the Lord argument. Lord, the theme of the argument, we are not going presently on 34, because Lord, almost everybody has argued on 34. Your Lordship, Lord, when the question was referred to this bench, also covered section 37, Lord, which for its scope and powers. So, Lord, we are going to start with section 37 because, Lord, our argument is that if section 37 is examined closely, and our argument is twofold. First, that it is the first appeal. Unlike, Lord, the argument which is being raised, it appears to be a second appeal, which is actually a first appeal. Your Lordship will see that from.
We are not
37.
examining that question. We'll leave it aside. Whether the power under 37 is equally wide as 34 or more restricted as some judgments have said, we are not going to go to that.
Lord, that will be necessary for a moment, Lord, for a simple reason. Your Lord,
Only to the extent modification. If we hold.
Lord, I'll just clarify, just for once your Lordship, Lord, once your Lordship sees it. Lord, the argument is simple. As far as Lord, today we have two, in fact, sides of judgments. One which says my lord, that 37 is narrower than 34. That's the one line of argument. The second, my lord, which is the liberal one, says that 37 is at best equal to 34. There is no line which says that 37 is
That
actually
can never
like
be, that can never be.
My lord, your lordship will bear with me for 5 minutes, then I will leave it to your lordship, my lord.
Are you propounding 37 is wider than 34?
Yeah, absolutely, my lord. We are saying 37 is like a regular appeal. If your lordship, my lord, sees,
Extrapolate, if the first trial court cannot go into the question, the
no, my
second.
lord, no, that's the reason. If your lordship, my lord,
Okay,
answer
please
to,
argue on that.
yes, my lord, answer to that lies in section 36. If your lordship sees 36, my lord, it will become clear. My lord, and the answer is after 36, because 36 uses two phrases. First is decree, that it award, it doesn't say, my lord, at the stage of the award that it is a decree. It says at 36, after the 34 scrutiny is over, that it becomes a decree of the court. And then it says in 36.3 that it is to be treated as a money decree. If your lordship will just have 36 minutes for a moment. And Lord, I'll also clarify why this power has been kept separate. And what are the kind, Lord, your lordship will also have to keep in mind that when we adopted the UN sectoral model, there are few provisions which are there only in our act and it is not there in the UN model. For instance, 34 capital 2A, which provides that two critical elements, that is the power to reappreciate the.
We are aware of that.
So, my lord, those two have been specifically kept in our act. They are not there in the UN.
But come by way of amendment.
Yes, my lord. My lord, your lordship will see 36 now.
Yes, please.
36, where the time for making an application to set aside the arbitral award under section 34 has expired, then subject to the provisions of subsection 2, such award shall be enforced in accordance with provisions of the Code of Civil Procedure in the same manner as if it were a decree of the court. Then your lordship will turn to the proviso of 3.
Yes, please.
Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such conditions as it may deem fit, grant stay of operation of such award for reasons to be recorded in writing, provided that the court shall, while considering the application for grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money decree under the provisions of CPC 1900. That's Order 41, Rule 5. So, Lord, we have a position where 36.1 is talking about it being treated as a decree, and 36 proviso 3, which says that it is to be treated akin to a money decree. Now, my lord, your lordship will turn to 19 for a moment.
Section?
19. Section 19, lord, which says determination of rules of procedure. Because, lord, the argument is also that CPC is not only a procedural law. To the extent an appeal is provided, it can also be considered as a substantive law. Your lordship has dealt with that, lord, in a number of judgments. 19.1. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Now, Lord, the argument which has already been upheld in ITI, the judgment, Lord, which by learned friend read in the morning, was that it is not bound, does not mean that CPC is excluded. It only says that the view can be more liberal. So, other than the principles of CPC and Evidence Act, an arbitrator could probably go and have a more liberal view. And in fact, Lord, that is the reason I am saying that the scrutiny of 37 has to be more rigorous, because 34 provides only for a curtailed scrutiny, and it is like a, Lord, it's a position, I would say, to the extent of going, to the extent of saying that it merges into the award, and it is for the first time in 37 that the decree or the award merging with the 34 order is actually tested. That is the reason, my lord, your lordship will not find any other
We have
provision.
understood that argument. That we can be private side, it's not a case of reverse pyramid.
Lord, okay, Lord, I'll leave that argument for the moment. The lordship
Come to any other argument.
Yes, my lord. Your lordship will see 19.4. 19.4 for a moment, my lord. The power of the arbitral tribunal under subsection 3 includes the power to determine admissibility, relevance, materiality, and weight of any evidence. Now, my lord, please envisage a position where there's an arbitrator who is not even a law graduate, because the International Act has provision where experts like architects or other construction experts can be arbitrators. Now, he is going to determine things under 19(4) with respect to admissibility, relevance, materiality, and weight of any evidence. Now, please, in this background, my lord, please come to 28 for a moment.
Yes.
28, rules applicable to the substance of the dispute. This is, my lord, where we are building the power for 37, where the place of arbitration is situated in India. In an arbitration other than international commercial arbitration, the arbitral tribunal shall decide the dispute submitted to arbitration in accordance with the substantive law for the time being in force in India. So, my lord, CPC in that sense, when it provides for an appeal, here we have a section 37. Lord, I am not.
Mr. Pushkarna, do not press this point more.
Okay.
You're not going to carry it forward.
No, my lord, can I just, no, just one more power, can I?
We have understood, but it's not going to help
Okay,
you
my lord,
further.
your lordships.
You're
can then refer to-
retaining somebody else's time.
Okay, my lord. What 3 and 2, your lordships, when your lordships is reading, can 3,
We
20
go
and
through
3
your
and
written
2.
submissions that with regard to 37, but we not press that one.
Okay. My lord, then your lordship will also, my lord, in that light, come now to 34, 2 capital A.
Yes.
Now, my lord, 2 capital A. and
Rather
the
than
reason I
red
was
was
reading that
so many
was-
lines.
My lord, 2 capital A.
34 to A.
Yeah, 34, 2 capital A, my lord.
Yes, that has been read from yesterday, so many.
Yes, my lord, I want to probably read it.
So you make your submissions, but there is no
Okay.
point in reading it again.
My lord, I will only read the proviso, my lord. Can I read the proviso?
Yes, please.
Yes, my lord. That an award shall not be set aside merely on the ground of an erroneous application of law or by reappreciation of evidence. So, my lord, this was the reason I was reading 38, 28 and 19 to say that those are the aspects which 2A has been specifically
We have
brought in
understood.
in
Please,
our
Kumar,
statute.
Let us put it very clearly. The argument that 37 power is wider than 34 is unacceptable. Maximum you can argue is 37 being your first appeal. The car will be coterminous as wide as 34. Subject to, obviously, in case there is, on the ground of perversity or fundamental laws of India, there is a finding. Probably if two courts, a tribunal and the trial court have examined that issue, one will say that one should not interfere, even if one has a different view. That is something which we do when we hear appeals on bail against, we do for, when we hear appeals with regard to cancellation of bail or acquittal, etc. That's all.
My lord, I would only say that your lordship says, I bow down to my lord of obviously what your lordship is saying.
That need not
37,
spend more
3
time.
plot-
Please, I don't think this will carry water. Let me be very
My lord,
clear.
then I would
You
only
are not
say
right.
this
You are not,
as-
Mr. Pushkarna, you are not right in assuming that moment a 34 is dismissed, it becomes a decree. Even on filing of a 34, unless there is a stay, it's an enforceable award after the 2015 clarification. The law, according to the court judgment, is always like that. 37 moment it is filed with party as a prima facie case, there would be again an interim or suitable interim order. So again, it won't, you are assuming that it is at that stage a decree and proceeding and forgetting the principle that an appellate power is coextensive with the original power. So please leave that argument as a Chief Justice.
Lord, I go down to that. Your lordship in the morning, Lord, if your lordship recollect, spoke about 151 CPC and the inherent powers. Now, Lord, when your lordship was talking about 151 CPC, it was in that light, Lord, order 47, order 41, rule 23 to 33, my lord, would also become relevant for reading along with 37C. Because, my lord, what happens when the court receives an appeal under 37C?
Mr. Pushkarna, don't press this more.
I'll leave it
I
to
don't
that,
think
but
it's
I
going to
have
cut
make an
time.
argument, that's the
And
point.
36(1) was, what you read was originally enacted, then 2016 amendment, it was broadened to make it more enforceable. So leave that, let's not go into all that. We cannot accept the argument that 37 power is greater and wider or broader than 34. Sorry.
That's the reason your
It's
lordship.
too,
Okay.
that
Then
do
I-
not convey the point anymore.
I'll leave it there. I'm not for the benefit of this court. I have a chart, Lord, I'll just hand over.
Okay, that is that.
This has a summary
Yes,
of
please. Anybody else?
provisions, Lord, which we have
Get
discussed.
call out the name.
Yes, sir.
Grateful.
So just 5 minutes, I think. The night watchman, one of the most points covered, madam, and just 3 points I want to point out. Just give the written submission. One of the 3 points which I'd like to focus on, and very quickly, my lords, is that under section 34, my lords, there's the inherent powers of court and there's a discretionary power. There is a discretionary power which is there under 34, and that gives its own power to modify. That's where the power of modification arises from. That is number one. Second, from that discretionary power also arises the power to sever parts of the award and set it aside. That's where it arises from. And if, my lords, there is no issue between the other side and us that severability is acceptable, then severability is also a kind of modification. And that I will just show one judgment on that. Now, if severability is a kind of modification, my lords, there is no bar on other forms of modification by the award. That's the second point I want to highlight. And the third part which I want to highlight is the nature of modifications. My learned friend has already read modern laminators, just 1 or 2 points there I'll put. So, my lord, just starting first, may kindly come to 1.1 of my submissions. That talks about 34 of the Arbitration Act. The Act gives a discretion to the court not to exercise the ultimate power of setting aside in every case. This is clear from the use of the word may. And in that case, in that context, my lords, I have cited R.S. Jivani case, that is PDF 258 of the judgment, common compilation of judgments, PDF 258 at PDF 286, where para 16 it is stated, may indicates that larger discretion is vested in the court, which has to be exercised in accordance with the settled canons of judicial discretion. And the context would require that the expression may should be read as may alone and does not invite any other meaning or interpretation. So, my lords, with the inherent powers of the court, with this concept of discretionary power, which is there, my lords, to be exercised for judicial, as per well-settled judicial canons, my lords, I would suggest that this is the origin of the power which would come to modify the award. Then, my lords, may kindly come to cases where, my lords, in 1.3, that where parts of the award have been set aside on the ground that it is, my lords, the logic which is put forward, which is that each part of an award is like an interim award. The severability is distinguished from modification in the Delhi High Court judgment by Justice Verma by saying that each claim is like an interim award. If you set aside that interim award, that part of the arbitration goods is actually a power of setting aside which is being exercised. My lord, with respect, my lord, the argument which I would comment is this. The Act distinguishes between an interim award and a final award. It provides procedures under which a final award is to be passed. Once a final, unlike an interim award, which is passed and it can be challenged also, the arbitral proceedings cease on a final award being given. Once the arbitral proceedings cease and it becomes a functus officio, my lords, it's treated as a final award. Now, to read in a fiction into that, contrary to the Act, that actually, no, it's not a final award, it actually is a conglomeration of different sets of award, is stretching the language too far. I would rather comment the argument that, my lords, actually this severance is a form of modification. It's one type of modification. And under section 34, that is not the only type of modification which can be exercised. There can be other types of modification of award within certain guardrails, which I will point out. So, my lords, I come to straight away at page 3 of my written submission, 2.1, where I've defined modification as a change to something, an alteration or amendment. And then, my lords, Puran Lal Lakhanpal, I have quoted, my lords, I'll pass on the judgment. I won't take time to read it out, but just the relevant para. The word modify means inter alia to make partial changes in, to change as object in respect of some of its qualities, to alter or vary without radical transformation. Similarly, the word modification means the action of making changes in an object without altering its essential nature or character. The state of being thus changed, partial alteration. Stress is being placed on the meaning to alter or vary without radical transformation on behalf of the petitioner. But that is not the only meaning of the words modify or modification. The word modify also means to make partial changes in, and modification means partial alteration. So, my lords, that is the scope and ambit of modification, which has to be given full play to from the discretion of the court under 34(1). Then, my lords, I may just come down to the final point which I want to make. I won't take much time. And that is the nature of modifications, other kinds of modifications can be carried out. It would be dangerous to limit it to certain types of modification. The inherent powers of the court are there, case by case, depending on a case, the court may exercise. For one point I wanted to make regarding 34(4). 34(4) is not a suo motu power which can be exercised by the court. It has to be a party applying. And in the Kinari case at para 14, I will not take this court's time, but my lords may make a note. And in the Kinari Malik case, at para 14, this aspect has been dealt with and pointed out. So, my lords, it is something where the court waits for one of the parties to exercise. But, my lords,
The language of the statute itself is very clear.
yes. Yes, my lords, language is, that's why. So that's why I'm saying that as far as 34(4) is concerned, it's a completely different genre. When we are talking about modifications to be carried out by exercise of powers by the court, my lord, that has to be traced under 34. My lord, that's my submission. Then, my lords, may kindly come to, so Kinari have dealt with, and my lords, finally, I would like to come to modern laminators, which my learned friend has already read out, Mr. Ritin Rai, that it has to be within the confines. And that confines, my lords, here I will comment one more submission. My lords had mentioned, may see 3.4 of my written submission, page 5.